Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murder Sheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via.
This season, Instacart has your back to school. As in, they've got your back to school lunch favorites, like snack packs and fresh fruit. And they've got your back to school supplies, like backpacks, binders, and pencils. And they've got your back when your kid casually tells you they have a huge school project due tomorrow. Let's face it, we were all that kid. So first call your parents to say I'm sorry, and then download the Instacart app to get delivery in as fast as 30 minutes all school year long. Get a $0 delivery fee for your first 3 orders while supplies last. Minimum $10 per order. Additional terms apply.
Achieving a gorgeous grin from home isn't a total mystery with Bite Clear aligners. Just don't be surprised if all of your sleuthing friends start asking, "What's your secret?" Begin by ordering your at-home impression kit today for only $14.95. Bite Clear aligners are doctor-directed and delivered to your door. Treatment costs thousands less than braces. Plus, they offer flexible financing, accept eligible insurance, and you can pay with your HSA FSA. Get 80% off your impression kit when you use code WONDERY at Byte.com. That's BYTE.com. Start your confidence journey today with Byte.
Content warning. This episode includes discussion of the murder of 2 children.
So today in the Delphi case, there was a court hearing in Fort Wayne that, unfortunately, due to some circumstances, Kevin and I were not able to attend. The good news is that some people were able to attend, and those are some awesome case observers who've been doing this for a long time. They go, they know everything about the case, and they take excellent notes. And 2 of those people, Angie and Sarah, were generous enough to share their notes with us and let us know what they saw, what their impressions were, and what happened today. So today, they're going to fill us in, talk us through their notes, talk us through what happened, and we're all going to sort of analyze together what this May 7th hearing meant and what will be surely some pretty big ramifications for the Delphi case. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is The Delphi Murders, new trial date. So, Sarah and Angie, thank you both so much for coming today, for helping us out. We really appreciate it, and just want to start off by saying both of you are people who have been covering this case for a long time. You've been interested in it. You've been going, taking notes, and you're both people whose notes, whenever we'd see them, we were like, these are really good. So we're just so enthusiastic and thrilled to have you both here today. So just wanted to start off by saying thank you.
You're welcome. You're welcome, guys. Thank you.
I guess to start off with, let's just start at the beginning. And we'll just kind of give you both an opportunity to respond. But what's sort of the first thing that happened in this May 7th hearing?
Well, you know how usually when we got in line and we went up to the courtroom doors were closed as before, and we waited for somebody to open them. Well, they were unlocked, and nobody told anybody. So we all gathered in the hallway until one of the gentlemen come and let us in and notified us that bailiff did that the doors have always been unlocked. So anyway, we went in. The usual people were there. The families from Abby and Libby, Richard's mother and wife was there. And then the first attorneys then came in would have been the defense team, and that consisted of Rosie, Baldwin, and I'm going to call her Jennifer A. because of her last name. And there's a little bit of back and forth in the court proceedings that will cover that for you. And then the prosecution team, which was Nick McClellan, Stacy Diener, and Mr. Luttrell. Also with him was Holman, Lieutenant Holman, Detective Vito, Steve Mullins, who is the investigator, as you know, for the prosecution, and ISP support staff. Ex-Sheriff Chuck Lesenby was the person in charge of overseeing for Carroll County. As you know, Carroll County and Allen County both have to be in the courtroom since this is a Carroll County case.
And there was one special guest today that I didn't know who it was. It was the Attorney General was there.
Todd Rakita was there?
Yeah. And we found out a little while later.
Well, she didn't know Todd, but we found out.
No, I mean, I did. Yeah, I didn't know.
Because he represents the state of Indiana and their employees. And as you know, there is a section order of employment records and stuff for the employees at Westfield and at Wabash.
So Rakita didn't talk, but he was present.
Right. He was present. And when when the hearing was called to order, we found out why. But I just wanted to say, just to add to what Sarah said, Judge Gall came in around 8:26, and she was very calm, and she had a focused discussion with the staff, and Miss Jennifer Auger from the defense was also speaking to them at that time, which ended up becoming a little bit relevant later once the hearing started. But when Baldwin come in, so Rosie and Auger entered and set up everything, sat down, got right to work on their laptops. But Baldwin come in just a little bit later, like a couple minutes later, and with support staff, and they had these trolley carts that they brought a whole bunch of stuff in, like two large, like what you would see at a concert when they're pulling. Yeah, with files and stuff. So they were set up for a full day today. Definitely.
Yeah.
And I found that interesting after what ended up transpiring.
Right, because as we'll get to, this was not a full day.
And obviously,
I think they thought they were going to do. My thought was, because they kind of opened, I thought that they were going to. I think they thought they were going to do the motion and Lamine first.
I think that's what Mr. Rossi thought was going to transpire.
And that's not what happened.
That's not what happened.
So what did happen?
What did end up happening?
Judge was very timely, as she always is.
Yeah.
She called the court to order. Called the case. They called the case number, and at that point, that's when Rossi asked Judge Gall exactly what we're going to do today. are we going to have the scheduling hearing, asking to change the length of time for the trial, and also the order for living fresh. And then she pulled the record and read back to him his order, his request for this pretrial hearing. So obviously, and she said, we're going to hear them both. So this was at the initial part of it. They had intended on hearing both motions today, but that's not, as we know, not what happened. So I'm going to let Angie take it from here.
Well, the issue seemed to be about the limited appearance that had been filed for Ms. Auger. And they had a sidebar, and they approached the bench on that like almost immediately as soon as Judge Gull came in and called the order. Allen had come in with 3 Allen County deputies, not IDOC, escorting him. And I guess you've seen the new booking photo that was released last night that Judge Gull had some things to say about a little while later. But they basically approached the bench in a sidebar right away regarding Miss Auger. And she said, Judge Gull said, I don't know her name. She said she greeted Baldwin and Rosie. And then she said, I'm sorry, I don't know your name.
I don't know you.
Yeah. And then the limited appearance discussion was almost immediate. And Rosie asked to approach because it might have an impact on what she could present today. So they wanted to, sort that out and not cross any boundaries. Everybody was very calm, focused. Just there was no inclination really that it was going to end as quickly as it did. There really wasn't. It was very, wasn't it? Wouldn't you say?
Up to the point that this with the attorney.
Yeah. And
even though they were at the sidebar having the discussion, she did question whether she has a limited appearance for digital type.
It was a deposition for the FBI.
Right. So that's Jennifer Auger. She's definitely a limited appearance attorney in this. And I want to ask you both, just before we get on with the legal elements, how did Richard Allen look? I know we've all seen this new booking photo, but for folks who may not have seen it, what were your impressions about him? Was he looking healthy? Did he look different? What were your thoughts?
Oh, he seemed to look groggy at first when he got there, but as things started to progress, he did look like he's probably put on another 15 pounds. He has more of a full beard now.
He was very unkempt in his beard. Yeah, and I thought when I looked up at him, I thought he looked like a hunchback, like all hunched over, like he was but when he come in, at 8:58, 2 minutes before Judge Gull called to order, he came in and looked for Kathy and Janice and his mother and wife. And Baldwin immediately started talking to him for quite some time, actually. And then Rosie got up and came over and squatted down beside him and had a discussion with him as well. And this all just basically happened within the few minutes before she called the order.
Understood. So we had that kind of interaction with his family and then his lawyers. So that's definitely a pattern we've seen at some of these hearings.
Yep. And Max, the intern from the defense, and another intern were seated in the front row with Kathy and Janice there. And so they sat in their usual spot.
Was the courtroom a full house today?
Not by any means.
No.
Wow. Okay.
And the entire defense side of the seating of Allen County was full. And then we had, because I looked back because I was going to do a count. And then I noticed that it was all full. And then on the prosecution and family side, we had one row of family and then 2 rows of, there was plenty of extra seats. It was by no means full. It was not the same scenario as the March 18th contempt hearing.
So what was the next thing that happened in terms of the lawyers and the judge?
So Robbie did announce that he had put in the paperwork to Jennifer A., as I refer to her, will now become part of the defense team as a whole. She won't have a limited appearance. And Judge Bill said she hadn't seen the paperwork on that, but when she does, she'll take a look at it and sign off.
Oh, wow. So he's getting a new attorney, like an additional attorney, I should say, to fully represent him through this.
Right. Well, but we don't know if that's going to be a limited amount of hours that she's going to allow, or is she going to allow an unlimited amount of time?
Understood.
But she'll be able to cover more than just the FBI interrogation.
Not too sure, because they did file another appearance for her that said criminal, but
that would be for
she did not approve it.
Right.
So there was she
had not seen it yet.
So there's some question about what will happen going forward with that, but it sounds like they're kind of slotting Miss OJ in for more work.
Yes, and actually there's some sort of a disconnect with this IDOC issue with the that they talked about. That was how it all come up about the the Attorney General, rather. Like right away, there was something that was entered and dated on May 2nd and put through the CCS, which I assume is their system. Court never entered it as an actual order of court. So there was something.
There's a stipulation to it also that Mr. Rossi will see the records prior, but then after that, they will be under seal. So these are employees of the IDOC, which Rakita, he is our state attorney, so he is responsible for those employees. Since we don't have the other two that represented the employees that were getting their appearances dropped off. And so once he receives those, he wants to review those, and then he asks the judge to put them under seal.
Have you ever covered a carpet stain with a rug? Ignored a leaky faucet? Pretended your half-painted living room is supposed to look like that? Well, you're not alone. We've all got unfinished home projects. But there's an easier way. Thumbtack is the app that makes it easier to care for your home. Pull out your phone and in just a few taps, search, chat, and book highly rated pros right in your neighborhood. Download Thumbtack and start caring for your home the easier way.
This episode is sponsored by AutoTrader. Credit scores, down payments, interest rates. Car buying can be a numbers game, but you don't have to be a math expert to get the keys to your dream car. Just use Kelley Blue Book My Wallet on AutoTrader. Crunch your numbers and get your personalized results so you know exactly how much you'll pay each month for your car. It's like having a magic wand for your wallet. Presto! The car you've been wanting is now within reach. So hit the road and leave your calculator at home. Find your next car on autotrader.com.
What makes a life a good one? Is it the adventure you have? Or the friends you find along the way? Maybe it's pursuing your passion while striving to protect, defend, and save what you believe in every single day. So, what makes a life a good one? In the Coast Guard, we think it's all of the above and more, but you'll have to find out for yourself. Visit gocoastguard.com to learn more.
Understood. What happened next after some of this IDOC and Jennifer OJ matters were sort of dealt with?
So
we went into the time.
The time, right off the bat, Rosie started discussing about the times, and Rosie stated that each witness list currently has over 100 on it, with probably 50% of them duplicated. So not everyone's going to be called. So help me out here, Sarah. I'm reading my notes.
He tried to explain that he felt like with only 2.5 weeks, a lot of time, that it would be not enough time for the defense to put on what they had planned, and that the judge was trying to restrain the time, and it would be against the end of the trial. That he said it's just not enough time for him to properly defend, for them to properly defend Richard Allen in court. And he brought up that the prosecution brought up the fact that they had indeed whittled their witness list down to 45 witnesses. And the state was definitely satisfied with the time that is being allowed and that they would be done with their case by the 25th if the dates stayed as they are.
Wow. So the defense, the prosecution is saying we're ready to go.
They streamlined. Nick made it very clear. They've streamlined everything. They've done he said, we've done everything we can. The state doesn't have any objections. They have 6 to 12 chain of custody witnesses as an example out of that 40 to 45, and they're ready to go. And Rosie stated quite a few times that they require 15 business days in court, and he wanted to know how they're going to divvy up the time. Like, if the state takes right till, if we were going with the old court date, if they took right till the 26th, does that mean we get a couple of days to do our case, and then we're going to end up having to retry this whole thing again? So Rosie was trying to look for a solution, a practical solution, and it was all quite civil. So Judge Gall asked, what is your request then, Mr. Rosie? The first time I'm hearing that the time isn't adequate was April 30th.
And then we go into, once he brings up that he needs at least 2 weeks to present, or 15 days to present, and that the questionnaires had already went out, and in the jury packets, it included the dates, and that he suggested bringing in the jury and asking them at that time if they would mind to add on the extra week. And she said she could not do that under
jury rule
4 that deals with the jury selection process, because the length of time is definitely on the jury selection time. Those are things that she cannot change, and there's nothing she could do about it. So I think at this point, everybody knew where we were headed at this point.
I imagine.
It was still quite civil. It was like it never got. Actually, I shouldn't say civil. Rosie wasn't heated yet.
His voice kept going up higher.
Quite equivalent. Yeah.
He was getting a little bit louder with whenever he was asked a question as far as from Judge Gold. Well, what do you suggest? What do you suggest we do? And her hands were tied as far as what she was able to do on her end. And so from that point, we go into another point where I'll let Angie discuss at what point Rosie asked about having a 5-minute break, go and recess for about 5 minutes so he can have a discussion with his client.
Oh, well, we skipped a little bit there, Sarah. So I know I'm looking. Well, okay. Well, Rosie got very animated and was pointing down and very loud directly at Richard Allen and saying that it's his right to have an adequate defense. And Allen was very engaged when he was doing that. And then Judge Gall talked about the 6-way phone calls and the emails, and that's not how I do business. And I don't know what you want me to do when I only found out about this objection about the time length, April 30th. And I should say Rosie did originally back at the June 15th hearing last year. When Judge Gall set the trial date, she set it for 2 weeks to start in January 2024. And Rosie made an objection at that time, and he did reference that today at the hearing. He said, I brought it up myself, although he said
that was in October, the first part of October, when he said he brought his concerns up to her again.
I believe he talked about both hearings today, but originally, she turned around. Judge Gull added an extra week at the June 15th hearing and made it this was during the hearing, made it 3 weeks. And then, the stuff happened in October. So Rosie requested the 5-minute recess, and she asked why. And he said, I would like to have a meeting with my staff and talk to Alan. And Nick didn't have any objections. So they took a recess. and then what happened there?
Well, they come out, and at that point, he comes back in. They go back on the record. At that point, they're talking.
That's when Judge Gull went through about 4 or 5 different cases.
Well, first Judge Gull, Mr. Rossi was complaining that he did not have a private conversation with his client due to the fact that Allen County deputies had to stand at the door and keep their eyes on Mr. Allen. First, he complained about that, and he brought up another subject, and it had to do with the judge ending the trial on the 31st, and he's never been told a time limit like that as far as when a jury trial would end. And so then she fired back at him about, we can't communicate through email because I don't want to see my emails in your motion. This is when things start to get a little bit more. So the email we saw last week that you guys you read on your last podcast, which was really good, that was not supposed to be in that motion.
Wow.
That's really interesting.
Yeah, that sounds like things are getting heated.
Yeah, to say the least.
Yeah.
You could tell this had been coming. The intent, and granted, there should have been some pre-trials, which I kept wondering, when are we going to start seeing some of these pre-trials? And she then went into discussion about when Mozzie was bringing up about the evidence. Now we're still this is just now coming back after conversation that he couldn't have a private conversation with. And then at that time, there was an open office in the courtroom that they could go into by themselves, and it would be a secure room, and the Allen County deputies would not have to be in place. And Rosie said, "What's the point of that now? I've already had the discussion I needed to have with him."
Right. So Judge Gull actually said we could do that right now, because Rosie made the point that it had happened before when they've been there with Alan, that there's been, guards present and they don't have full privacy. And Judge Gull immediately asked her, the fellow in charge of the court, the bailiff, immediately. And she said, we can do that right now. And he said, it's too late now. That ship has passed. And so then he made he brought up about the 15 business days that they require to give an adequate defense. And then he withdrew the speedy trial. And then, so that was very short. He made a few sentence statements about withdrawing the speedy. And then Baldwin stood up and he had a motion to request that she be disqualified, that you be disqualified, is what he said to her. And he said, do you need a copy? And she said, no. She says, it needs to be e-filed. No, I'll read it after. And I believe it was 24 pages that they referred to that motion to disqualify her. And then she asked Nick if he wanted to respond to that. And he said no. And she said, you can respond to it after it's been filed, and that's fine. So then she confirmed that Alan is waiving his right to a speedy trial. Rosie answered yes, and she immediately set the date of October 14th to November 15th. She made mention of 8:30 a.m. with court starting every day at 9 a.m. And then my favorite quote. I gotta finish.
But one thing we do need to touch on is that the defense and the prosecution are not communicating very well either, because of the same fear of the emails ending up in motion when there's supposed to be private communications going on between them.
Right. It seems like communications have sort of broken down to a certain extent, in the sense that people are doing things that the other parties are not happy with.
But Angie, what was your favorite quote?
Yeah, I gotta know this.
Okay, so she said, well, I have it written down of course I have.
Well, let's put it in perspective, because first she mentioned over the hundreds and hundreds and hundreds of murder cases that she dealt with in criminal cases, including
over 27 years.
The explosion up in Marion County. Remember that one? The big case up there in Annapolis.
Yeah, Richmond Hill.
A case involving a stalker that murdered his wife and 3 kids. Well, she mentioned several different cases, but by this time, the defense was really they were very, to the point of being unprofessional in their tones, because the other courtrooms could hear Mr. Rosie's voice. I do have to say, she stayed very calm through it all. She never raised her voice, and there was very little talk involved. And so I'm going to go ahead and let Angie.
Now I'm going to do my quote.
It was probably one of the best quotes of the whole that was said.
It was quite shocking. I think.
Yeah.
All right. So Angie, what was it?
A gasp was heard.
Yeah, because it does seem unprofessional to me.
Yeah, it was a little bit startling.
It was very, to me, it was unprofessional in the line of work that they do. It was an unprofessional thing to say, but I'm always go ahead and let Angie share that.
So Judge Gold set her date for the new trial immediately in response to them withdrawing the speedy. And she said, he made comments. You read that? That's your note.
Rosie had pointed out that she had denied almost everything he had put in.
Right. Yeah. And then Gull responded, if you can't try this case in that amount, gentlemen and lady, there's something wrong. I see no reason why it can't be tried in that time. And Rosie responded with you don't know anything about this case. And it was...
That's amazing. How did she respond to that?
That's what he said, and he was very firm, and it was like, there was a moment.
It was to me, it was very unprofessional.
Yeah. Well, yeah.
How did she react, though? Was she, mad, or was she just, did you just not?
Amazingly, she had no reaction at all to it.
Wow.
She saw her shake her head a little bit.
She said, after 27 years, are you telling me that 30 days isn't long enough? And at this point, Richard Allen was not engaged. He was just staring down. And she said, she also continued on and said, why don't you have these discussions and let me know? It is patently clear that the defense and prosecution are dealing with each other in written form only. And then Rosie responded, and I missed the response, but then she said, we are all here now. Why don't we have these discussions now? And
so what did happen instead if they weren't discussing what they were there to discuss?
Well, I actually left at this point because we had the motion to disqualify her and a new trial date. And she granted the motion to continue. I don't know how they're specifically going to file a motion to withdraw the speedy or a motion to continue or what have you.
She granted that.
So Sarah will continue on with the rest of the observations.
She granted that the speedy trial be dropped and reset for October 14th. through November 15th. I am assuming that she'll go Monday through Saturday, like her original plans are. And then she had also asked the state if they had any response to what had just transpired with this being now a month-long trial. And which I totally agree with, the burden of proof is on the state. It's not up to any defense attorney to say anything. The burden is on the state to prove that person is guilty. Mm-hmm. So with the tone that was set, and you could see that this wasn't going to calm, you could tell it wasn't going to calm down. Baldwin once he gave her that 24-page motion for her to recuse herself, and she just shook her head, and she said she hadn't read it, and he asked her if she wanted a copy of it, and she said, no, you can e-file it, and I'll read it on there.
There was no reaction to that at all. Reaction. She had no. So it was very. She was.
So and let me just interject here quickly. So just let me kind of go over everyone's sort of mood, mm-hmm. and you can tell me. So McClellan speaks very little during this. Judge Gull's pretty calm, maybe stony faced a bit, and Baldwin's talking less than Rosie, and Rosie's yelling basically the whole time. Yeah. Very heated.
Yeah, he worked his way up. He worked his way up too.
Very similar to the June 15th, 2023.
Yeah, I remember thinking he was somewhat had somewhat of a lack of control during that June hearing, and so it's surprising that he's sort of gone back to that strategy.
Mm-hmm. A very different one than what was in there March 13th or 18th when you were here.
March 18th, yep.
Yeah.
Right, during the contempt issues, right?
Yeah, right. The state did bring up if they were going to discuss today the Franks hearing, and immediately Judge Gull said no. But it was kind of like the state, and that would be Cleveland said, "Are we going to be hearing Franks number 2 or 3 or whatever number we're on?" And she said no.
Wow. So, I mean, it sounds like it kind of got a little bit out of control, frankly. And the second Kevin and I are not there, then obviously then it's going to be some dramatic
nobody shows up
nonsense.
In the audience. Things get out of hand.
Well, it was, in fairness, though, you guys were there in June of last year. You saw a bit of the tension that slowly build up. So it kind of like build up, but it built up a little bit faster.
The language was from when Rosie came out, and he was very, I have all this, what he said, and his speech was very deferential, and he was very considerate, and, it wasn't like a groveling type of speaking or anything like that, because I kind of saw that at the contempt hearing from Hennessy. But no, it was just normal. It by all appearances, didn't seem like it was going to go the way it ended up going.
Right, and I just
we were headed down this path of a new trial date. I think the majority of that have followed this case.
Yeah, kind of. It's obvious. They're still doing depositions. They haven't looked at the discovery yet. They're not preparing opening, fine tuning their opening statements. Right? I like to say, like at this point right now, when the trial starts next week, they're not.
No, but the state's ready to go.
Yeah, Nick is ready to go.
And both sides of
very obvious.
They both had the evidence in their discovery that did come out rather quickly, but it was done.
Let me just ask you both something. I just want to sorry to cut you off. I just want to ask, did the defense give a reason for their nixing the speedy trial other than, or was it just a matter of we can't get a longer time in May because of the jury rules and therefore we need to move it back?
The time constraint they felt would hamper they wanted a full 15 days to put on a defense. Okay.
So was there anything else covered in the hearing before it wrapped up?
Yes, yes. So they have set May 21st, May 22nd, and May 23rd. Starting at 9 o'clock in Carroll County, we will have the defense's 2 suppression hearings and the state's crime, and all that will be in Carroll County. There was also a concern brought out about the notification that Allen was being housed at the Allen County Jail. Judge Bill brought this up, and she looked and talked with Rosie about this. She was very upset that news got out. And I felt the same way. That you decide a safekeeping order by letting that information out and notifying everybody where Richard Allen was last night.
Yeah, because last night there was a mugshot released, and it revealed that he's now in the Carroll County Jail, and that caught a lot of people
Allen County
Jail.
Allen County Jail.
That was not to be released.
So did they explain what the heck happened there? Like, why was it released?
Well, the defense didn't know it wasn't supposed to be released.
So did they sent it to journalists? Or the defense did?
We really don't know. It didn't come clear, but she was leaning towards the defense with that.
Okay, so yet another instance of the defense maybe doing something that ticks off the judge.
We're slowly building up, like, unprofessionalism.
Right.
I mean, you're putting the client in grave danger when you're doing stuff like this. And another thing is that when we got back to the hotel, here I get a message on my Vine account, and it states on there that Richard Allen is being transported back. He has left Allen County Jail. But I never got one that he was moved yesterday. And so that was supposed to be kept under for his protections because he is in the care under a safekeeping order for a reason.
Yes, and we know that in prisons and in jails, people who are perceived as having harmed children are at an especial risk from other inmates in terms of violence.
So, absolutely, and this was supposed to have been done and be kept quiet.
Yeah, that's shocking.
It was easier for Richard Allen to, be able to get there and rest overnight and then go to court the next morning. So that was the judge being considerate of him. But I don't think they were ready. That was not to be released, but it was.
So how did this thing end?
Oh, so it ended with the discussion over how and when that all got released and how upset she was over that. And it ended with the scheduling of the hearing, which will, since they had them dates already reserved for the actual trial, they're going to use 3 of those days for the suppression hearing and to plan to go all day on all 3 days.
Okay. And then that was it, basically?
Yeah, we'll see you guys up there.
Yeah, we'll be there.
We'll definitely be there. And we just thank you again for going and for taking such good notes and for sharing your insights with us.
This has really been fascinating. We really appreciate both of you. Before we go, are there any other things you wanted to mention, or do you want to share your opinions about any of this?
Yeah, impressions.
Yeah, I'm going to, because I have been to almost every one. I think I missed one hearing, and that was very far back in February of 23. And there's a certain amount of respect you have in a courtroom. Even us little people, when you go into a courtroom, there's a hierarchy and there's below it, just like in any other, but there is a certain amount of respect to be shown to a judge. She's being painted as a very unfair judge, but she has guidelines. She has rules she has to go by, and she's following those rules. These are hard decisions. As you know, you sat in a courtroom last October 31st with me and heard negative things said about Judge Gull, that if she had been a man, I would not have been called, she would not have been called that. And I think that the unprofessionalism has to stop, or they're going to be butting heads all the way through, and it's actually harming the client.
Well said, Sarah. Angie, what were your impressions?
Well, I was prepared for that to go longer than the contempt and dismissal hearing. I thought we were going to be that motion and the mean was going to be, I thought we were going to be grinding it out over Odinism and Ron Logan and the Klein, Todd Click. I thought that in and of itself was going to be a full day, to be honest. And judging by the looks of the carts that they wheeled in, full of files, I think that's where we were headed. But it just didn't happen, and it's just another day in the bubble, as I like to say. It's just, you can't predict you can, but you can't. There's always some surprises.
And real quick, probably, I think my definitely final thought on this, and I know, and yet, being in the law and judicial system, Richard Allen he is innocent until he's been proven guilty by a jury of his peers. But so much of this upheaval and this stuff needs to stop, because in the middle of these, we lost 2 innocent young girls. I don't know. I have not heard the evidence. I can't say, and anybody who says he's guilty or he's innocent, really, that's an opinion or speculation, because nobody's heard the evidence.
Mm-hmm.
The state of Indiana has been extremely tight-lipped.
Yeah.
But we need to remember we lost two little girls, Abby and Libby, and we can't forget that.
Yeah.
Thank you so much for this.
Yeah, you both have been wonderful, and just thanks for doing it.
Oh, we think the world of you guys. You can edit that part out, but don't tell nobody.
Oh, Sarah, we're leaving that in. We're leaving that in.
We want that in for the record.
That's on the record.
You've worked hard to build your brand, so why settle for one-size-all-fits branded clothing? Lands' End Outfitters creates apparel your employees will truly want to wear that unites your team in comfort and style. It's clothing that bolsters your brand identity and creates a unique connection between your brand, your employees, and your customers. It's why Lands' End Outfitters has been a supplier of branded apparel to some of the world's most respected brands for more than 30 years. From logo polos to fully customized branded wardrobes, our world-class outfitters will partner with you to help your team feel confident on the job and put your brand into action. From logo application to online ordering, Lands' End Outfitters offers seamless solutions that give you peace of mind, all backed by above and beyond expertise. See why Lands' End Outfitters should be your branded apparel partner. Go to business.landsend.com/pod20 and use code POD20 for 20% off your first product. That's business.landsend.com/pod20. Code POD20 for 20% off your first product.
Well, Anya, before we wrap up this episode, why don't we take a couple of minutes just to try to talk out and figure out what we think about all this. First of all, it was disappointing not to be there, but I really appreciate Angie and Sarah being our eyes and ears today.
Absolutely. They were just amazing for doing this. They were able to give us insights. We also had a couple of other conversations on background with different people who were there. So I feel like because we just, were able to rely on people who care about this case, we ended up with a decent perspective on what happened. So we really appreciate both of them and everyone else who talked to us.
Now, Anya, knowing you as I do, I suspect you might have some strong feelings.
Well, yeah, I'm pretty, disappointed that this is not going to happen in May. We were both, I think, in a position where we were doubtful of that at different points and then allowing ourselves to believe it and then doubtful. And just to be clear, this whole thing is very grueling for everyone involved. So I would have liked to see it over with for that reason.
And yeah, keep in mind that if people who follow the case or people like us who cover the case, it's grueling for us, but think about how this must be for the families and to be kind of jerked around. Oh, it's going to happen this day. No, it's not going to happen this day. that's hard. It's hard.
I always felt that the defense was somewhat facetious in filing for a speedy trial, and I'm going to explain why. We know from previous filings that they had this document, essentially carte blanche, essentially, where they had just Richard Allen sign it at a random time and they threw it out there. So, and we heard from other defense attorneys that seemed like sort of a weaponization of speedy trial. I had a feeling that it had a lot to do with the fact that they were being tried for contempt. And honestly, none of what happened today sort of absolves them from that in my mind. I think that this is an instance where this was a strategic filing, and not necessarily a fully sincere one. And I'm kind of doubtful at this point. While I would like to see, obviously, them get as much time as possible, I think with another defense team, I would probably be more sympathetic to the argument that we need more time. But with these people, I just don't know. There's been so much, frankly, flim-flam and nonsense going on that I don't. Do they really need that much more time? I mean, what?
Here's where I'm at. I don't know. I don't know how much time the defense needs to do their case. And also, obviously, I don't know. Nobody knows if they're going to be allowed to include the Odinism stuff.
That's what I mean. If half of their people are going to talk about Odinism, or or some YouTube commentator who's going to tell their theory, and those aren't going to be allowed, then how can they even determine how much time they need?
So we don't know. We don't know. But what I would have liked to have seen is Judge Gull pointed out that she did not get any communication from the defense about how much time they needed, or rather, she did not get any communication from them that the time allotted would not be sufficient until April 30th. And it is difficult to believe that on April 29th they had no problems, and on April 30th they suddenly did. So they probably should have notified the judge of these types of issues pretty quickly after filing the order for the speedy trial. And if they had done so, I'm inclined to think that the jury questionnaire could have been written in such a way that maybe the trial could have happened.
It's almost like they don't really want it to go off in mid-May, and they just self-sabotaged until that inevitably fell apart. Again, I'm not saying I know that for a fact. I don't know what's in their heads, but I think people who are serious about making something happen tend to be more methodical and meticulous about how they approach that goal. When we want something to happen, we check different things and make sure that nothing is happening that could preclude what we want from happening to go off without a hitch. And in this case, it doesn't seem like they did that. So you're looking at either incompetence, where they're just not thinking to do these things, and it's a mistake, it's an honest mistake, but it's still a mistake, or it's a matter of, well, we don't really want it to go in May. That's just posturing. So, who cares? We're not gonna make those statements. We're not going to send those emails to get it all planned properly. I don't understand it. I tend to look at it as just sort of cynical at this point, because that's sort of what I've seen so far from this team. I've not seen, we've seen a lot of this kind of thing happen. So the benefit of the doubt is something that I'm not willing to extend at this point.
Also, I'm very curious to see Baldwin's motion for Judge Gull to be disqualified. Apparently, it's a pretty lengthy one. I think they said about 24 pages. And the reason I'm interested in seeing this is that they tried to get her disqualified by the Indiana Supreme Court. And the Indiana Supreme Court said in January, no, nothing she has done rises anywhere near the level of disqualification. So if you want her to be disqualified, you would have to look at things she's done since January of 2024, when she was essentially absolved by the Indiana State Supreme Court. And it's difficult for me to see what she's done since then that would be such an issue.
She's found them not in contempt. She's ruled against some of their filings, but that ruling against a lawyer's filings is not indicative of bias. That's just not how it works. people can read in whatever they want to specific actions. But as far as the court is concerned, that the judge has discretion to, rule against or for whoever they want. So, I mean,
they're just trying to create a record. So if they lose, maybe an appeals court judge can look at this and say, oh, maybe,
But good luck with that, given that the Supreme Court has said she didn't. Basically, what the Supreme Court said is that she reached for the eject button when she should have reached for like the, shields button. She did the wrong thing, but we've corrected that by bringing the attorneys back on after she dismissed them. So it's a matter of, we fixed the issue, but did she do the wrong thing? Yes. Have we corrected it? Yes. But also, was her impulse, was her heart in the wrong place? No, because she didn't have the benefit of hindsight and she was scrambling to protect the case. So basically, they gave her a thumbs up on that. And it's not, and frankly, they kind of did her a huge favor in what they wrote, because they sort of gave her a blank check, because they almost absolved her of any contention with the defense prior to the Supreme Court hearing. They're saying, this is all fine. So as Kevin said, the defense would have to nail her on something after.
Now, it's pretty clear from what we've just heard from Sarah and Angie, and what we've seen in other filings and stuff, that the defense doesn't like the judge and the judge doesn't like the defense.
Well, it seems at this point that the defense is the ones really coming at this from a more hostile place from what they said.
In fairness, in her contempt decision, I think she called them sloppy, negligent, incompetent. But the thing is, before I started working with Anya, there were times in my life where I worked with people I didn't like. And you just have to be a professional and rise above it. And it doesn't say in any Indiana state constitution or federal constitution that I'm aware of that you have a constitutional right for defense attorneys and judges to be best friends.
Yeah. They don't need to be going over to each other's houses and hanging out and doing weekend trips together. They just need to be professionals and make it work. And frankly, something that I've observed throughout this process is from the defense sort of an interesting set of priorities in terms of who they're writing their filings towards for and who they are sort of speaking to. Normally, in a normal case, you would see both sides writing filings for the benefit of the judge, an audience of one. Hey, judge, here's why we're right. Side with us. In the defense's case, we have not seen that. We have seen again and again, essentially press releases disguised as filings. And we've seen a kind of, in my opinion, disturbing willingness to sort of speak to what I would call people who are like cranks and conspiracy theorists. And I don't feel like from their side there has been much of an effort to get along with the judge. We even saw that early on where they essentially had some sort of in-chambers conversation with her where they said, we're not going to try it in the press. And then it's almost like a cut in a comedy movie to like them releasing a press release, and that's, I don't think that's contemptuous, but it's certainly not, that's not the behavior of attorneys who are trying to get along with the judge. I feel like they essentially wrote her off very early on and have just been doing whatever they want. And then when she gets annoyed at them, then maybe they're using that as sort of ammo to go after her for being biased. I don't really see that as necessarily a long-term effective strategy, because I think the record is not necessarily going to be on their side in that situation.
Anything else you want to cover?
Well, I would say again, I'm disappointed that we're not doing May. It sounds like, I really question how long this trial needs to be at this point. And I don't know. I guess I'll say this. I've said this before, but I'll say it again. I really, really feel like someone needs to get to the bottom of what Richard Allen wants in all of this. And I don't know. I'm not a lawyer. I don't know what the process of that would be. But if this man is being used as a pawn by other people in order to, have some outcome that others want, That's not fair to him. He has the right to do whatever he wants. And he should be getting support from people who are, hired to support him in this process. And there's been things in this case where I've been disturbed to see that he does not seem to have a real grasp of what's going on. And that is not good. And the fact that it's been diverted to October at this point is disappointing. I think that's probably good for the defense to have more time to prepare. I felt that they were completely unprepared for May. Judging by what's happened so far, I don't know that they'll be prepared for October, but I certainly hope that they consider, getting ready, because I think they're really going to need to be ready for this.
Well said. Thank you for listening, everybody. We'll talk with you soon.
Thanks.
Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.